Let's say you did something wrong. You know you did something wrong. You want to take responsibility for it. And you want to make sure that even though you're taking responsibility, you don't get the book thrown at you. You don't end up in significant incarceration or the worst case scenario. I'm Josh Camson. I'm a criminal defense attorney with Miller, Turetsky, Rule, McLennan. We serve clients all across Pennsylvania, helping to keep them out of jail and fight charges. Let's talk about it. Okay, so let's say you've decided you want to plead guilty on a case or you think you're going to be convicted on a case. Here's two very important ways that you can try to lessen your sentence even if you're guilty. Number one, a mental health assessment. Critical. Judges love to see this, and it's great. It's a great tool for the lawyer. What do I mean by a mental health assessment? Whether it's a psychiatric or a psychological assessment, going in and talking to someone and kind of reviewing the things that you have going on in your past, whether that's physical abuse, mental abuse, substance abuse, we'll get into drug and alcohol in a second, sexual abuse, whether something happened to you as a kid or an adult, if you've been in an abusive relationship, if you suffer from anxiety, if you're neurodivergent, whatever the case may be, all of those things form a much bigger picture of you and why this may have happened, how this may have happened, things that may have led to this happening. And all of that is great, what we call mitigation evidence. And we'll get into mitigation in general in a second, but it's all going to be ammo for the attorney to use to get a lesser sentence, either with the judge or as part of a plea agreement. And the second thing you can do, try to lessen charges or lessen the sentence rather, is a drug and alcohol assessment. So many people that are charged with crimes or that have committed crimes do so because they're trying to feed their addiction. They've got a substance abuse disorder or it's a drug case, whatever the case may be, doesn't matter. Getting a drug and alcohol assessment if you have a substance abuse disorder, if you've abused drugs in the past, so important, so important. That professional, that drug and alcohol professional, can get into your background, and especially combined with the mental health piece. If you've got a mental health and substance abuse disorder, what we call a co-occurring situation, that's even more evidence that the defense attorney can use to try to mitigate the sentence. What do we mean by mitigation? When you go to sentencing, and I'm going to post a whole video about sentencing guidelines in Pennsylvania and how those work. When you go to sentencing, there's a mitigated range. And the defense attorney and defendant need to present to the judge or to the Commonwealth if it's going to be a plea agreement, some of that mitigation evidence. That mitigation evidence includes things like trauma in the defendant's past, having a substance abuse disorder problem, really anything you can learn from a mental health evaluation or a drug and alcohol evaluation or both. And those things allow the defense attorney to argue why the sentence should be less. And it also allows you to show to the court, this is a real person and it's a real person struggling with things. It's very easy for judges to just kind of get used to it. They see people commit crimes and plead guilty or get convicted every day, day in, day out. And it's so easy for these cases to become just another number. But as a defense attorney, armed with the right ammunition and information, it just makes it so much easier to say to the judge, Judge, this person is a person. They've got a past, they've got a history, and it might not be a good history. It might not be a good past. And that's why they're here today. That's an argument I've made successfully many times and that lawyers across Pennsylvania and across the country probably make successfully all the time. But we can't do it, and the lawyer can't do it without the proper ammunition, the proper tools in their toolbox. That's why the defendant needs to be the one to get the drug and alcohol evaluation, get the mental health evaluation, and talk to their lawyer about their past, about the things that have happened to them, how they came up, why their life went the way it did, that they found themselves in the situation they found themselves in. Those are all great ways to try to lower a sentence or go to the Commonwealth and get a better negotiated sentence. I'm Josh Camson. I'm a criminal defense attorney. If you found even a little bit of value in this video, please drop a like, give us a subscribe so you can see the other content we've got coming down the pike. And hopefully you're not in this situation, but if you are, I hope you enjoyed the video. Thanks a lot.